In Islamic law, the continued ability of the husband to maintain his wife is not a condition for the long-term binding nature of the contract. But in modern state law, lack of maintenance becomes a ground for divorce. The continued ability of the husband to maintain his wife does not make the contract of marriage uncertain and non-perpetual. According to Imam Shafi'i, it is a condition for the continuity of the contract of marriage, and the wife has the right to seek separation. The Dissolution of Muslim Marriages Act, 1939, passed in India, says that where the husband neglects or fails to maintain his wife for a period of 2 years, it becomes a ground for the dissolution of the marriage. The right has been acknowledged by the courts and is treated as an independent right. The courts have interpreted 2 years to mean a single continuous and unbroken period of 2 years and not an aggregate of several periods amounting to 2 years. And these 2 years should immediately precede the suit for dissolution. Neglect has been interpreted to mean willful neglect to maintain wife. Burden of proof lies on the husband. That is, he has to prove that he maintained his wife. Accordingly, where the husband for some reason is unable to maintain his wife, but the wife is living with him, the cause of action should not arise. If, however, the husband intentionally deprives the wife of her maintenance or does not keep her at his house, that is, fails to provide her residence, the cause of action for dissolution of marriage definitely arises. It is, therefore, suggested that separation from the husband, caused by the husband, should be made a condition in such cases. If this is the case, the period of 2 years laid down in the law appears to be lengthy and may be reduced. The position taken in the Hanafi law is that marriage is a contract that is different from a commercial contract. A major purpose is that the husband should maintain his wife according to prescribed rules. But it also implies that as the contract is not a commercial contract, the wife has to bear the vicissitudes of life and endure the hardships of family life according to the status of the husband. Some courts have, however, treated reasons of poverty, failing health, loss of work, or any other cause as immaterial. We would say that this amounts to treating the marriage contract as a commercial contract, and treating the marriage contract as a commercial venture reduces it to the level of prostitution. It converts the position of a wife into that of a woman hired for physical access and sexual relations at the will of the husband, along with the household chores she may have to perform. This will also lead to questions about the extent of maintenance she deserves or is entitled to. Treating marriage as a commercial contract is a position that is untenable. Therefore, we have sided with the Hanafi jurists on this issue